Is it true that under the Catholic faith, marriage is permanent till death? Does the Catholic faith agree that marriage can be dissolved? Does the Bible recognize divorce? The judge has given Amos 3, verse 3, and also 2 Corinthians 6, verses 14, saying a marriage is not only the day people walk down the aisle. It is a continuous process. It is a vision shared. If I was myself, I'll say that marriage is a game of two fools, two consenting fools. They must agree. That's what the judge is saying. If they don't agree, one has eyes, the other one is a fool, that marriage will collapse. So the judge is saying, whether you have done a wedding in church, it does not stop the other party going to court for divorce. The other party has a right to go to court. How can you avoid the other party going to court? Be the person you are when you are seducing each other. Be the person you are and do what you promised each other. The concept of till death do us part can only be realized if the man and the woman love each other. If there is no war, if there is no pressure, if there is no stress, if they love each other. But if there is stress, if there is animosity, the court is saying the option for divorce is available. The judge is challenging the stereotype that if you are divorced, you are a failure. If you are not married, you are a failure. If your relationship does not work, you are a failure. The stigma of society. Many people have mental stress. Many people are walking, talking all over because of the stress in marriage. The judge is saying, if it doesn't work, walk out. It can give you good health. Welcome to Court Helicopter Explainer. Today, we are entering into a very, very slippery ground. Religion, faith. We apologize for the position we will take because that is the position of the law. This is the question that concerns the Catholic faith. Does the Catholic faith agree that marriage can be dissolved? How many Catholics are there? Is it true that under the Catholic faith, marriage is permanent till death? This is a question of personal faith. We know very well, Article 32 talks about everybody's right to religion and conscience. But also, Article 45 of the Constitution allows for creation of marriage between a woman and a man. So the questions that are coming, furious, at the time the people are marrying, they are serious Catholics. They are joined together under the priest or the father in a Catholic place. They take their vows. Once they have taken the vows, they are not given the Catholic marriage certificate. There is no marriage certificate that comes from any church. All marriage certificates come from the government, the Attorney General. So here is a situation. We are sorry, but this is what we have got to discuss. This is a matter that has just been decided by the High Court recently. This is the case of Peter Kimari Gathirimu versus the Attorney General, the National Assembly, and Mary Wanjiku Wambui and the Kenya Conference of Catholic Bishops. This is a tough case. You hear the parties? This is not an easy matter. And that is why my crew, Vivian, when she brought this to us, we had to discuss, are we going to lose our followers who are Catholics? Are we going to be seen not to be sensitive to the Catholic faith? But we said, from Court Helicopter, this is the authority, that is petition number E106 of 2023. What does it deal with? The petitioner's case is that on 23rd August 2019, he and the first interested party, Mary Wanjiku Wambui, solemnized a Christian marriage in the Catholic Church at the Shrine of Mary Help of Christians. But that on 6th March 2023, his wife, MS Wambui, filed a divorce via the petition number MCDC/E307/2/2023 at the Chief Magistrate's Court at Milimani, Law Courts. The petitioner alleges that as a faithful adherent of the Catholic faith and the leaders in the said church, he believes that marriage is indissoluble, and that by being cited as a respondent in the divorce petition, he is being compelled to engage in a divorce proceedings, which is an act contrary to his beliefs. He asserts that the determination of the divorce petition filed by his wife, the first interested party, forced him to violate the tenets of his Roman Catholic faith by dissolving their marriage under Section 65 of the Marriage Act. So the question is simple. These are two Catholics. They are married under the church, but they are issued a marriage certificate. The wife gets annoyed, files for divorce. The magistrate's court grants a divorce nisi. Aggrieved, the husband runs to the constitutional court and raises the question that his belief, his theological belief, is that marriage once consecrated cannot be dissolved. This is the question that was put across before the judge, and the judge looked at all those arguments. Let us see. He argued that the Marriage Act is discriminatory. It ignores the Catholic canon law. What did the judge find? The judge in page 18, paragraph 64 says, this court finding is that a failure by a specific denomination to successfully steer the final statutory language to its theological linking does not equate to a failure to public participation. So the judge went into the Bible. This is the most interesting part, that the judge went into the Bible to get what does the Bible say about the divorce. Does the Bible recognize divorce? To us, that is the most important issue. Remember, this Catholic faithful is saying the Bible does not recognize divorce. The judge goes further and finds out that in paragraph 86, far from discriminating, the Marriage Act treats all citizens equally. It is also important to point out that to exempt Christians who are Catholics faithfuls from divorce would itself be discriminatory and undermine Article 27 on equality and non-discrimination, because this would be denying them access to civil remedies available to them. The judge says Article 27 includes the Catholics. He moves on to paragraph 8. She moves to paragraph 89. The petitioner contends that being forced to undergo the divorce proceedings in the magistrate's court subjected him to humiliation, and forced him to submit to a process that does not preserve his faith, in violation of his right to dignity. However, while balancing all competing rights, human dignity includes autonomy and the ability to exit harmful or abusive relationship. If that were not to be the case, the Bible, the judge now is giving the shock of life. If that were not to be the case, the Bible, which is the holy book for Christians, would not have the scriptures such as Amos 3 verse 3, which reads, and I quote, "Do two walk together unless they have agreed to do so?" There's a question mark. Do two walk together unless they have agreed to do so? This is the judge posing that question from Amos 3 verse 3, which points out that a measure of agreement is necessary if two parties are to work together. This scripture verse, while originally written about God's covenant with Israel, the principle of shared direction, mutual commitment, and unity makes it one of the most fundamental guidelines for Christian marriages. The judge proceeds to apply Amos 3 verse 3. In applying Amos 3 verse 3 to marital life involves several key impressions. First is the shared destination and vision. A couple must agree on their life goals, core values, and spiritual direction. Secondly, is that working together is not just about the day that the couple exchange their vows in church, but is a conscious, continuous choice to compromise, work through differences, and row the boat in the same direction. Third, is that this verse is equally linked to 2 Corinthians 6 verse 14, which warns Christians not to be unequally yoked with non-believers, emphasizing that a shared faith makes it much easier to walk the path of marriage in unison. The judge has given Amos 3 verse 3 and also 2 Corinthians 6 verses 14, saying a marriage is not only the day people walk down the aisle. It is a continuous process. It is a vision shared, is a continued shared. If I was myself, I'll say that marriage is a game of two fools, two consenting fools. They must agree. That's what the judge is saying. If they don't agree, one has eyes, the other one is a fool, that marriage will collapse. This is what the judge is saying, that Amos 3 verse 3 and 2 Corinthians 6 verses 16. Paragraph 91. Additionally, although the Bible, being a holy book, does not outrightly advocate for divorce, from the readings of several scriptures, they all acknowledge that divorce is possible. The judge is saying the readings of several scriptures acknowledge that divorce is possible. Let us see what the judge is saying. Paragraph 92. Mark 10 verse 9 and Matthew 19 verse 6. It says, reads that, therefore, what God has joined together, let no one separate or put asunder. What God has joined together, let no one separate or put asunder. End of quote. The judge says, yet the same Holy Bible gives two clear grounds for divorce. The judge is saying the Bible provides two grounds for divorce. One, paragraph 92, still, the ground for sexual immorality is found in Matthew 5:32 and Matthew 19 verse 9. The second ground is abandonment by an unbeliever, which is found in 1 Corinthians 7, verse 15. This scripture stipulates as follows. Let us read Matthew 5, 32. But I say to you that everyone who divorces his wife, except on the ground of sexual immorality, makes he commit adultery. And whoever marries a divorced woman commits adultery. The voice of the Lord in Matthew 5, 32. I repeat, but I say to you that everyone who divorces his wife, except on the ground of sexual immorality, makes he commit adultery. And whoever marries a divorced woman commits adultery. That is the voice of the Lord in Matthew 5, verse 32. The judge moves further in 1 Corinthians 7, verses 15. And the voice of the Lord. But if the unbelieving partner separates, let it be so. In such cases, the brother or sister is not enslaved. God has called you to peace. I repeat, 1 Corinthians 7, verses 50. The voice of the Lord. The Bible. But if the unbelieving partner separates, let it be so. In such cases, the brother or sister is not enslaved. God has called you to peace. That is those are the two verses the judge has said. Paragraph 93. He says, the Bible does not acknowledge that two people walking together are capable of disagreeing, and if that happens, parting ways is an option. No one disputes that marriage is sacred and that it is what the Holy Scriptures teach. Additionally, although the Holy Bible does not encourage divorce, nonetheless, because marriage is a voluntary union, any party to it may withdraw, and the Bible provides for two main reasons. One, sexual immorality or adultery, and abandonment or desertion, as reproduced above, which are also two main grounds upon which divorce may be sought and obtained from the court, as stipulated in the Impugned Act and Section 65 of the Marriage Act. Paragraph 97. The judge says, while freedom of religion is protected under the Constitution, it cannot be used to invalidate laws that serve legitimate public purpose. I reiterate that the Marriage Act 2014 permits, but does not compel or mandate divorce. Therefore, what emerges from the Act is that a spouse's individual right to seek an exit from a broken marriage overrides their partner's theological preferences to keep the marriage legally intact against their will. The judge in paragraph 109, he says, conversely, Christian churches globally have historically recognized the secular state's ultimate jurisdiction over the civil contract of marriages, relying on internal church discipline and conscience to guide the members. Parliament's choice to regulate Christian marriages under a unified civil regime while preserving the constitutionally recognized Kadhi's court structure is a legitimate legislative classification applicable to members of the Islamic faith, and this does not in any way amount to unfair discrimination under Article 27 of the Constitution. The petitioner tried to argue that the Catholics are lumped together with all Christian churches, or all Christian faiths in one marriage act, while the Muslims have theirs separate under these courts. The judge found out that there is no discrimination between the Muslim divorce proceedings and the Christian proceedings. 110. The petitioner argues that by exchanging lifelong vows under the Catholic rite, both he and the first interested party executed a permanent waiver of their right to seek for civil divorce. This court must state categorically that while certain procedural constitutional rights can be waived, a citizen cannot contract out of fundamental civil protections or statutory rights established for public order and personal welfare. A marriage vow, however sacred, and I repeat, a marriage vow, however sacred within a place of worship, cannot operate as a legal estoppel to bar a citizen from accessing the courts to seek statutory remedy. The right to access to justice and the right to individual safety and autonomy cannot be signed away in perpetuity. The judge is saying the fact that two people have taken vows, religious vows in church, do not operate as estoppel. My crew Vivian told me kindly, tell the people what is estoppel. Estoppel is a principle where you say, if you told people you will provide them this, you cannot one day say you cannot provide. You are bound by what you say. So the judge is saying, whether you have done a wedding in church, it does not stop the other party going to court for divorce. The other party has a right to go to court. How can you avoid the other party going to court? Be the person you are when you are seducing each other. Be the person you are and do what you promised each other. Be the person you are, kind, loving, caring, no violence. If you become violent, the other party will go to court. If you abandon, the other party will go to court. If you are involved in adultery, the other party will go to court. So people cannot suffer because of their faith. That is what the judge is saying. Harm, if anybody feels a threat to harm or real harm, he will go. Lastly, paragraph 111. The man's frustration and religious devotion and convictions are clear. However, the High Court cannot mutate into an ecclesiastical court, nor can it impose the internal theological doctrines of the Roman Catholic Church into the secular statutes of a pluralistic nation. This court concurs with the submissions of the second respondent that if indeed the Catholic community, and in this case the petitioner, desire a distinct statutory framework within the Marriage Act, their proper constitutional path is to lobby and petition the National Assembly under Article 119 of the Constitution for that enactment. So the judge is saying, yes, we know there are courts within the canon law. They are called ecclesiastical courts. These are courts within the church. The church has the structures to discipline its members. The church has structures to deal with matters internal. But when it comes to matters provided by the Statute of Kenya, and I said it, the judge is right. The marriage certificate issued in church is a government document. It is not a church document. So the judge says if the Catholics are aggrieved, they can go to Parliament and petition Parliament to do that. Paragraph 14, in conclusion, 114, in conclusion, it is important to appreciate that marriage is fundamentally a partnership rooted in voluntary commitment and mutual happiness, not a coercive or imprisoning arrangement of until death do us part. The judge is saying the concept of till death do us part can only be realized if the man and the woman love each other. If there is no war, if there is no pressure, if there is no stress, if they love each other. But if there is stress, if there is animosity, the court is saying the option for divorce is available. Recognizing and appreciating marriage as a flexible and respectful institution allows for compassion and dignity for those facing unfulfilled or harmful relationship. Thus, ending a marriage can be a positive step towards personal growth and well-being rather than a failure or moral failing. The judge is challenging the stereotype that if you are divorced, you are a failure. If you are not married, you are a failure. If your relationship does not work, you are a failure. The stigma of society. The judge is saying, in the contrary, the judge says, thus ending a marriage can be a positive step towards personal growth and well-being. Many people have mental stress. Many people are walking, talking all over because of the stress in marriage. The judge is saying, if it doesn't work, walk out. It can give you good health. If it doesn't work, divorce. You can grow further. Has your career ever stagnated because of a marriage? Are you in a relationship, in a marriage, where you are told you cannot go to do your degree if you never did your degree? You can never go to do masters. You can never go abroad to do a course. You can never attend a workshop in Kisumu because your husband thinks you are going to cheat. Are you in a relationship, in a marriage? This the judge is saying. You cannot go to evening classes. You cannot eat outside with your colleagues. You cannot do anything for personal growth. Are you in a relationship? Are you in a marriage where you can't own your own business? Your husband is paranoid if you start your business, your side hustle. He wants to check what you're doing. Are you in a marriage where you can't open your bank account alone? You can't go and take a loan. You can't freeze your account without the consent of your husband. This is what the judge is saying. Some divorces do not serve any wrongdoing. They allow personal growth of the person who is divorced. Paragraph 116. What did the judge say? The petition dated 30th March 2023, as amended on 17th July 2023, challenging the constitutionality of Section 65, 66, 66, 73 of the Marriage Act 2014 is found to be devoid of merit and is dismissed with the entirety. 2. The court declines to issue any declaration incorporating the Catholic Code of Canon Law into the statutory corpus of the laws of Kenya. Lastly, all other orders sought in this petition are declined and dismissed, signed and delivered virtually at Nairobi this day, 17th day of June 2026. 17th day of June is just 2 days ago. This is the latest decision. What is the import of this matter? The judge is saying marriage is not an imprisonment. Marriage is not committee prison. Marriage is not Langata women's prison. If it can't work, walk out. 2, marriage should not, religion should not be used to detain somebody in a marriage that is not working. The court has allowed that marriage, whether it is between two practicing Catholics, the court has jurisdiction to dissolve this marriage. So the notion that marriage is not able to be dissolved under the Catholic canon law has been found by the Constitutional Court that violates the rights of individuals. We apologize for the Catholics, but that is the law. We might be accused that we are doing profane, we are doing what the Bible does not agree, but we swore on oath that Court Helicopter will bring to you the law as it is. It's not us. This is the position of the law. This is a contest between Article 32 and Article 27 and Article 45 of the Constitution. And the court has upheld Article 45 is not unconstitutional. Article 45 agrees with the rights of every citizen in this country. Keep watching as we are celebrating getting 70,000 subscribers. We started small, we have grown big because of you. We appreciate your contribution, we appreciate your comments, we appreciate the time you take to listen to us, and may God bless you as this Bible, the judge, has put it. Wakili Dan Sanomar.